What's going on, y'all? Attorney Tom here. In today's video, I'm going to be doing a USCSB react of the video titled The Animation of the 2018 Ethylene Release and Fire at Kuraray America in Pasadena, Texas. As many of y'all know, I'm a catastrophic personal injury lawyer located in Houston, Texas, and unfortunately, you can't be a catastrophic injury lawyer in Houston, Texas without doing refinery work. And although I wasn't involved in the Kuraray case, I know a lot of the lawyers who were, and I was also following the case as it went through the legal system, so I feel like I have a lot of good insight to give. Let's get started. Attorney Tom. I don't take sponsors. The only thing I ask is that if you need a lawyer, contact my team for a free consultation. While most people know me as a catastrophic personal injury lawyer, I'm actually a partner at 2 law firms that handle way more than just catastrophic injury. If you were the victim of securities fraud, received a notification that your info was included in a data breach, developed cancer as a result of a bad drug or toxic exposure, and many other situations, we may be able to help. It's important you talk to a lawyer right away to understand your options. If your case is not the best fit with us, we can help you find a great lawyer by using our national network of attorneys. Please click the link down below for a free consultation.
May 19th, 2018. The Kuraray America chemical plant in Pasadena, Texas. The plant manufactures Eval, a copolymer made from ethylene and vinyl alcohol. Kuraray shut down the Pasadena plant on April 6th for a maintenance turnaround and to install various equipment upgrades. By May 18th, Kuraray operations personnel were taking steps to bring one of 4 reactors back online. The reactor, known as Eval Reactor 2, looked similar to the others, but had a lower maximum design pressure of 740 psi. The design pressure of the other 3 reactors was 1150 psi.
So the very first thing that comes to my mind is, why does this reactor have a different PSI rating, right? Does the reactor accomplish something different, or is it just an older or different model reactor? But the narrator says that they are near identical. So I want to know what the purpose of that reactor is. I want to know, did they have any safety measures to distinguish that reactor from the others? What did the operators of this reactor do to make sure that there was never any confusion? Yeah.
The reactor already had liquid methanol and ethylene vapor inside as operators began incrementally raising the reactor system pressure. They did so by adding additional ethylene vapor. Pressure was raised in order to reach the target pressure necessary for the reactor to start up, while also checking for leaks. In the meantime, chilled liquid from the plant's newly installed refrigeration system was circulating through the reactor's heat exchanger. After 11:20 p.m., the reactor pressure, together with the low temperature from the chilled liquid, created conditions that allowed the ethylene gas in the reactor to condense to liquid. This caused the temperature in the reactor to decrease. Around 7 a.m. on May 19th, a supervisor noticed the low temperature in the reactor and instructed operators to stop circulating the chilled liquid through the heat exchanger. The reactor was surrounded by a heat transfer jacket, which uses water to control the temperature inside the reactor. To further help warm the reactor, Kuraray personnel periodically added steam to the jacket, increasing the temperature of the water. As the temperature of the reactor increased with each injection of steam to the heat transfer jacket, some liquid ethylene inside the reactor vaporized. This raised the pressure inside the reactor. By about 8:45 a.m., the reactor reached the target operating pressure of nearly 600 psi, but pressure continued to increase. Around 9 a.m., the pressure reached 640 psi, and the high-pressure alarm went off. A board operator responded by periodically opening a pressure control valve to send some of the vapor inside the reactor to a flare.
Okay, so a board operator responded to the situation by releasing some pressure. But what I want to know is, how quickly did the board operator respond? What was his training? Additionally, what other mechanisms did the operator have at his disposal? Meaning, if there's a scale from 1 to 10, 1 being the least drastic measure you can implement and 10 being the most drastic, where did they go, right? Because oftentimes in these cases you see, quite frankly, it's just negligence on the fact of the operator, because they're responding to a level 10 threat with a level 1 response, if that makes sense, or a level 7 threat with a level 3 response, right?
The board operator was concerned about exceeding environmental emissions limits for the flare. As a result, he did not fully open the pressure control valve.
Okay, so the pressure control valve was not completely opened because of some non-safety related issues.
He was also focused on other startup activities and did not realize the valve was not open as much as it needed to be.
Also focused on other activities.
Shortly after 10 a.m., operators initiated the next step in the startup. At that time, a new board operator took over and noticed the pressure in the reactor was over 700 psi. But the operator did not recall that this reactor had a maximum design pressure of 740 psi.
Okay, so new operator, still going through with procedures despite the high pressure rating. And more importantly, as we identified in the very first part of the video, the operator couldn't recall that this particular reactor had a lower PSI threshold. Why? Why was this one different? And if it is different and it needs to be different for another reason, why isn't it clearly marked? What training, what sort of notifications did they have?
Like the first board operator, the new operator only partially opened the pressure control valve, not realizing how dangerously close the pressure was to the reactor's limit.
So now you have two separate operators only partially opening the pressure control valve. Why? Two people makes me think that there's a pattern here, either a lack of training or different priorities. I mean, that's a pretty terrible coincidence.
The partially open control valve was not enough to relieve the pressure in the reactor. Shortly before 10:30 a.m., the emergency pressure relief system activated. High-pressure ethylene vapor discharged from the reactor into the atmosphere. It was released horizontally toward an area where many people were working.
So having a potential issue with too much pressure is foreseeable when you're in a refinery. So next, the question is, what systems do you have in place to mitigate those damages? And I would argue that having a pressure release valve that points horizontally in the direction of where people are working is not mitigating anything. In fact, it is probably making it worse. And it does make it worse here.
Soon after, a nearby welding machine likely ignited the vapor, and a large fire erupted. 23 people were injured, many as they urgently tried to evacuate. The ethylene-fueled fire stopped after approximately 3 minutes, when the emergency relief valve closed as pressure in the reactor normalized.
And a whole lot more people than just 26 or whatever they said were actually injured in this thing. I think something like closer to 160 lawsuits were brought. Another thing that I want to point out is, why was this truck allowed to be here? I'm not saying that it shouldn't have been there, right? But obviously it was the ignition source. Why was it there? Should it have been there during those operation hours? Or was it truly just the design of the ethylene pointing horizontally instead of vertically, among other things that caused this issue? So now I'm going to talk about the lawsuits, and I'm going to go over some publicly available documents that I think are really interesting. Now, the first thing you should know is about 160 cases were filed, 160 individual lawsuits. Now, these lawsuits were consolidated in discovery, meaning the discovery was consolidated, but each victim had their own separate case. Now, the first thing you should know is Texas has really predatory workers' compensation laws, meaning if you are an employee and you get injured by the negligence of your employer, there's little to no legal recourse available, right? However, in refineries, oftentimes there is some third party that was negligent, either whoever designed the equipment or who failed to maintain it, or a number of different things. Now, what's really interesting about the Kuraray case is that it appears that the majority of the people injured, if not all of the people that were injured, I actually don't know the specifics, were actually contract workers and not employees, meaning they had the full legal recourse available to them, which thank goodness they did. Additionally, if you are an employee, you can get past the workers' compensation bar if you're able to prove gross negligence, which is an insanely high standard. So cases did proceed. All of that just to say is cases did proceed against Kuraray, in addition to whatever third parties there may have been. Now, behind me is a writ of mandamus or writ of petition for mandamus that went all the way up to the Supreme Court for this particular case. And you can go and read this entire petition online. Essentially, what they were fighting over was whether or not Kuraray had to produce the cell phone records for all the employees dating back a long period of time and not just from the exact incident. So the plaintiffs argued that the cell phone information was needed to determine whether or not employees in the control room might have been distracted by their phones when they should have been alerted to changing plant conditions that led to the release. In addition to the deposition testimony referenced in their motions, plaintiffs presented a January 23, 2018 email from an unknown sender to various Kuraray supervisors expressing concerns about cell phone abuse by board operators. So there seems to be a lot going on with the negligence of the operators. And this basically goes on to say, essentially, one, everybody should have been alerted. Two, it's possible that they were on their cell phones just being distracted. What's actually interesting is that the Supreme Court granted Kuraray's mandamus, meaning they restricted what could be held in discovery or what records the plaintiffs were entitled to, which personally, obviously, as a plaintiff's lawyer, I think is total BS. That shows a history, a pattern, a practice. We're not gonna get into the Texas Supreme Court in torts right now. Regardless, that was likely not a small issue, but I'm confident that the plaintiff lawyers in this case, had everything they needed to prevail and show negligence or gross negligence on behalf of Kuraray. And why do I know that? Well, Kuraray is a public entity, so we can look at what ended up happening in this case. So here is a memo from April 26, 2023, Kuraray America, headquarters in Texas, USA, subsidiary of Kuraray Co. Limited, reached settlements with the remaining plaintiffs in the lawsuits brought against Kuraray America in Texas, except one whose motion to dismiss is expected to be granted soon. The lawsuits have been substantially closed. Now, what were the effects of this? Well, the settlement amount. The total amount of the settlements incurred up to the close of the lawsuits is approximately $725.9 million. Now, you don't pay $725.9 million unless you have significant liability. Now, obviously, not being involved in this case, I don't know any inside details, but from the outside, it sure as heck looks like there was some negligence. All right, y'all, that's it for today's video. Bye.